What's up, family? It's your girl Ike here. I'm back with a recap of the Derek Chauvin trial. Yes, I am on StreamYard. Yes, my green screen is too small. Yeah, we've been over it. I know. You know me. I don't care. I'm not here for that. I'm not here for that. All right, so I'm streaming on Facebook on my regular page. I am on my fan page, the Ike Speaks page, and I'm on the YouTube page. Okay, so I'm hoping that we can get as much interaction as possible. Once again, I will invite you on to join me today. If you want to come on, I'll send you a link to come into the broadcast studio, and you can ask your question on the air live with the people. All right. What's up, Chakra King Black? Peace, King. Peace, love, me fro. Me fro. Oh, love my fro. I love my fro too when I have it out. when I got my fro going. So we're gonna be talking about day 8 today because it was really some powerful stuff that came out. And I really want to know what you guys think about it. I really am curious as to what your takeaways were today. And what do you think and how do you think the jury is going to respond to some of this? Hey, Kiki! What's up? Like you said you had some questions. I'm going to have to get you in here. Now, y'all going to see if I can do this right. Kiki says she has some questions. So let me see. Let me see if I can get Kiki and invite her to the studio. Probably not, because I don't know how to do nothing. Oh, wait, yes, I do. Yeah, I don't know. All right, I put the link in the chat. I hope. Tell me if y'all see it. I don't know. I tried. Peace, Petey Crack. Peace, L. Summers. You got so many questions today. Go you, Socrates. Everybody got questions. Twitter was on fire today, and I had in-person court, so I really couldn't sit and watch all of the trial. So I have Sirius on my phone, so I was listening to court TV on my phone, and then I listen in the car when I'm in the car. But you know, the time I'm sitting in court, I'm just sitting there like, this is some bullshit. Go on my case. Go on my case. But I did the best I could at catching up. I watched some clips. I watched some YouTube videos. I watched some of the testimony. So here's what we're gonna do. Keek, did you get it? You don't see it. All right, let me try again. Hey, Keisha. All right, it should be in the chat. All right, so let me just do a little bit of who testified over the past 2 days. So I wasn't here yesterday. It's a lot. It's a lot to do it every day. I don't know. This green screen is getting on my nerves. I'm gonna have to turn that all the way off. I'm gonna turn that off next time. Let's not be distracted. All right, I got my window open. All right, so we heard yesterday was a lot of testimony from Minneapolis police departments, training officers, the people who actually conduct the training for the police officers. They basically came in and were testifying about when Chauvin took certain training courses and things of that nature. They went through the different department policies, yada, yada, yada. But none of them were experts on the use of force, right? And if you were watched yesterday, you can compare and contrast how the testimony was received when it came to the expert Jody Steiger, what's his name? Jody Steiger, right? So this is I could not stand this guy. I'm sorry. I was like, how much did they pay you to say the bullshit you saying? That's just me, because I know how prosecutors roll. I know how they do, right? They will shop for whatever expert will say what they need to be said. So, and I say expert, I'm using this term hella loosely, right? Rather loosely, I'm using the term expert. Oh, I see you, Kiki. All right, I'll bring you in a second. Let me finish this little piece I'm saying. So Jody Steiger, he testified. He has a 28-year veteran, former Marine, and was an expert witness. And why am I using that term loosely? Because it didn't come out on cross that, in fact, he had never been an expert anywhere, everywhere. You know, you never testified in court as an expert. He said he was an expert, you know, doing this and doing that. But when it came to court, you never testified as an expert before. So this is your first time, and you're from California. You're an expert in the use of force for LAPD. So they send him all of this material for him to review and to come up with a opinion consistent with their theory of the case, right? They sent him some over 500, I think, documents, or some ridiculous voluminous tome of documents, of which he said he read most of it. He didn't even we don't even know if he read it all. What we do know is that he was paid a flat $10,000 and an additional $2,950 to come and testify at trial. So for one day's testimony, he made $3,000, and to take the case, he made 10 in total, 13,000 if they're telling the truth. Okay, I'm gonna bring Kiki in here. Hey, lady.
Girl, you know you got me. I got my glasses on, looking all crazy, but hunty.
So what happened, Kiki?
I got all kinds of questions because, you know, in my previous life, I was an attorney in my brain, right? Not for real though, but you know, I didn't confuse my Google searches with your law degree or anything like that. I do have questions. I just want to know. First of all, I agree with you. This Jody Steiger person. I'm not so much as, oh, this is your first time being an expert, because everybody's got to have a first time at some point. But really, did y'all really have to choose him in this particular case? Exactly. Right, for this time. This ain't a time for virgins, right? You don't bring a virgin to an orgy. It don't make sense. I'm just saying. So,
I gotta so I can put that on the screen. God damn it! Don't bring no virgin to the orgy.
Right. I got a question though. What is wrong with the prosecution's ability to object to stuff? It's like they don't object to stuff when it's like, duh, is that not like leading something? Is that like
right? So the defense has a lot of leeway, because remember, we're on the prosecution's case in chief. The defense can lead all day long. It's not improper. In fact, that's what he's supposed to do on cross-examination. So that's proper. That's wholly proper. They may not want to object. Just if they do have something that's objectionable, sometimes it's strategy that you don't want to object because you don't want it to appear that you're trying to hide something. Right? So instead of objecting, you just wait till your opportunity to redirect. Right? So they come back and then they just rehab or rehabilitate the witness in whatever way he had been heard on cross.
Okay. So let's go back to this Steiger guy and then this special agent from the BCA.
Oh yeah.
And the whole Jedi mind trick of I ate too many drugs. Too much drugs. Too much drugs. I know he was high. He let that goddamn high to say I ate too much drugs, but whatever, right?
That's not, yeah.
When I heard the first time when I heard it, I heard him say, I ain't had no drugs, or I ain't take no drugs.
Okay.
Or I ain't take any drugs is what I heard. I ain't take any drugs. That's what I heard. But again, I speak bruh, man.
Right.
I know a bunch of kids, people high and how they talk, right? I get the little nuances in our language, right? So it was like, I ain't take no drugs, right? I ain't take any drugs. That's what I heard.
Right.
Then he goes ahead and he says whatever. But the power of suggestion is the strong thing. And I'm concerned that the jury, that's going to be a sticking point in deliberations. That's going to give someone an excuse, huh?
I'm agreeing with you. I'm saying you bet your ass.
Yeah, and then the whole, he asked the Steiger dude once. He said, no, I didn't understand. He played again. He said, no, I didn't understand. He asked him again. I'm like, asked and answered. Damn it. Like, what the heck? How many times he got to say no? You can't force him to say he heard what you heard.
But he didn't need to. He didn't need to because he got it from the very next witness.
Right. And he did. He did. Very cleverly, right. I might add.
Yes,
and the other thing I wanted to say is I think it's amazing that the state has 14 attorneys working this case and they can't outwit this one dude.
They can't even put together. They can't even put together a decent line of a decent line of questioning.
Girl, so many times I'm like,
and they're the ones who are improperly leading.
Yeah,
I'm like, Nelson, why are you not on top of the table? Because that's what I'd be. I'd be like, Judge, I'm sorry, it's not my fault that they just can't formulate a proper legal question. It's not my fault, but I'm not gonna sit here with these fucking multiple choice ass questions you over there asking. You can't do that.
I think he's playing it right. He's already sitting next to a guy that people don't like, right?
Right.
General consensus is. So he don't have to come off as the asshole. So that just makes them both unlikable and not willing to want to take their side.
He could do that in sidebar, though. He can do that in sidebar where nobody hears him, right? Where the jury is out of the earshot and he can let them know. And that's what I do. I'm gonna put the spirit of fear in you so that every time you go to ask a question, you got to think about that shit 10 times.
And they should have thought about it anyway. What do they have? Like, they have like some second-year law students writing these questions. I mean, I don't know. No shade to second-year law students.
It's very bad. So with Jody, they never qualified him as an expert. Never.
Yeah, that was what they tried yesterday at the end of the day, but they abruptly cut it short. Next thing I know, he on this morning acting as a daggone expert. I was like, well, where did they lay the foundation for this? And when did they say? I don't know. I told you I think I'm an attorney, but I do see it.
Right. So let me explain it to the people, because typically when someone comes to testify, they are not allowed to offer opinion testimony unless you have been deemed an expert in a particular field. And then based on your training and experience and your observation of a particular set of facts, you can then draw a conclusion and have an opinion. How do you get to just give an opinion when you weren't qualified as an expert? And we found out that when he was cross-examined. So I don't know if they had maybe some, in limine, meaning that they had a sidebar where they just agreed, fuck it. And then Nelson was like, I'm gonna tear his ass up. Go ahead and do it that way.
That's me.
Do it like that. You want to.
El said, I'm gonna answer this question like I know, like I'm an expert. He says, will the jury have access to that audio when they're reviewing the case? The jury has access to all of the evidence that is submitted and accepted into evidence. So they can review all of that stuff.
That's right. They're gonna have it. So here's the thing. Last time we were on, we talked about this, Nelson bringing up this camera perspective bias. Remember that? And so it's not just what he said that's in contention. It's also, where was the need?
Here's my question.
Go ahead.
I have a question about that camera bias, because it cuts both ways. It can't be camera bias for me and not be camera bias for you. Right?
Yes.
So the knee, whether it was at the base of the neck, whether it was on the neck, whether it was on his back, we've established that in the prone position, handcuffed, it is a problem with them blocking somebody's ability to breathe. And for you to put your knee, and then you got the other guy who's holding his midsection area and the other guy holding his legs. So you compound all of that together and you expect, hey, listen, I don't even have to be handcuffed, but lay my ass on my stomach and watch me talk about something. Oh shit, I can't breathe. Right. And I'm not even under duress. Right.
But
I don't have
the problem is that George Floyd was saying that when he was being put in the car.
True. He was saying that I can breathe.
So it could be that the police officers who are used to dealing with people who just want to not be arrested and will say anything not to be arrested. I got claustrophobia. I got AIDS. I got coronavirus. I got everything.
Good, but you didn't put him in the recovery position. as you were trained to do. So you didn't even take the necessary step to mitigate. You know what I'm saying? Even if he had, let's say, for instance, he was just saying it just for shits and giggles to evade being arrested. Right. And you get him up and you put him in a side recovery position, or you sit him up and he's, flips out. It's still more y'all than it is him, right? And y'all can still get him in another situation. You know what I'm saying? You can still get him under control, but you never gave an opportunity.
That's but that gotta push back a little bit, right? Couple of things. Derek Chauvin came out today is 5'8" and 140 pounds. No, that matters. No, I know.
But he had on a 30 pounds worth of equipment, right?
Factor. It's a factor that the jurors will consider. Even if there were other officers there, they're not thinking about the other officers. It's what's in this officer's mind at the time. They all were struggling with George Floyd. Remember, he kicked so hard that he basically almost ejected himself out the back seat.
But what about the fact that let's get up to the point. I do agree that they should.
Let me respond to this point. You made the point about that they did not put him on a side recovery position, right? That's what you were saying. You're like, he was prone, and then at some point they should have put him on the side recovery position. Their position is we were holding him for EMS, right? And so Nelson was trying to establish that's not unreasonable and is part of police procedure. Now, the pushback from the prosecution was even while you were holding him, you could have been performing CPR. They're going to say, we did not know he was in distress. There is a body cam footage where they are checking his pulse. So they're going to say he had a pulse.
No, on the body cam, they said he didn't. The dude checked twice on the body cam.
The ambulance came.
No, before the ambulance show, he checked his pulse and said, I don't feel a pulse.
I thought he said, I do.
He said, I don't. And then here's all the things that I'm saying. You got this. I know you got a junior officer in you. We put him on his side, right? You got a junior officer. I understand you don't want to listen. You're the senior officer on the scene. I get that.
Right.
However, at some point, you had to notice that this man is no longer resisting you. It would have taken nothing from you.
I didn't notice that. I didn't notice. I was distracted. My attention was directed towards the different.
You got 3 other officers on the scene. If you can say
saying that he was gonna whoop my ass, calling me a punk while I was trying to do my job.
What?
Right. By the MMA guy, he was standing right there. He kept stepping off the step. He kept stepping off of the curb. Right. And so I kept looking up. I was at that point. Right. This is Derek. At that point,
I get it.
Remember, they called for the ambulance twice. Once at 8:21, I believe, and the second call was like 8:22, 8:23. And then there was an expert who testified it takes 5 to 7 minutes for an ambulance to come or whatever may have you. It's all about what is in the minds of these officers at the time. Is it reasonable for them to be concerned about a crowd that is gathering because they have somebody in a position that looks terrible? Hell yes. And the expert said that.
Let me ask this though. It's 4 y'all. It's about 10 of them. Only one is being vocal. You have an officer standing.
No, more than one was being vocal. They were.
I mean, vocal in the sense that he was aggressive. Aggressive. Okay.
Right, aggressive.
So, but you have one officer that's standing there, right? And so you worried about him? Are you not? You don't trust this dude that's supposed to be standing there controlling the crowd? My other thing is, this just came to my brain. That moment when the fire lady walked up and she was like, and he reached in and he grabbed his mace and he shook it. Don't your body weight is now on this man's neck while you are fucking shaking your mace. You don't think that has some.
But you don't think that goes to the fact that he really was concerned about the crowd, that he would take
that woman? It was a woman.
Exactly. It didn't even matter to him that it was a woman. It was a threat.
But my point is,
So much
But
so
my point is,
that
at that point,
right there, I still had to get a defensive, get my mace out because she almost made it past this dude.
wait, but hold on. Here's the thing, though. I get where you're going. I get you because you're a defense attorney. It's in your nature to defend the indefensible. I get it.
That's what I do, baby.
And my main concern in all of this, Akeisha, is that the jury is sitting here watching Nelson pick apart this case that they know what they saw with their own two eyes.
No, they don't. You cannot make that conclusion. See, this is where people get disappointed because you don't know. Some of those jurors had not seen the video. They had not seen the video. So this is their first time seeing a video. They don't have the benefit of the year that we all had replaying and commentary and seeing it. This is their first time. And so their first time seeing a video, this is also their first time seeing Nelson take that video apart.
Well, the first day that they played it, I think it was day 2 when they played it like back to back. And I'm like, what are they doing? The video is supposed to outrage you. It's not, you're not supposed to desensitize your jury to it. Yes. What are they doing?
And can you hardly even remember those witnesses from last week?
I do, but that I'm not the normal view. You know what I'm saying? Right, but again,
once they get in that jury room, right? It's going to be so far removed from them that they couldn't take the emotion into account anyway. But
let's ask this though. I got 2 questions, and I'm gonna get out your way.
All right.
The first question is, circling back to the camera bias. Would it be a good, like, say if I'm in the jury room and somebody's talking about, well, yeah, on this camera angle it said this, and on this camera angle it said that, but you got 8 to 10 people who all seeing the same thing.
Mm-hmm.
Let's just take the camera out of it. What they're seeing and saying, does that kind of combat that in terms of, yeah, okay, we got the camera evidence, we got all of that, you see that and this, that, and the other, but they seeing what they seeing. They're less than like 6 feet away, 10 feet away.
That's the thing, because they could take what the bystanders say. Oh, you got your knee on his neck, blah, blah, blah. But then they can't discount all of these experts who are looking at the video saying his knee is on his back.
But that was in like 3 specific instances, one early on, one midway, and one at the end when the paramedics had to get you up off of him. But again, those were in a 9-minute time frame, right? So let's just say, even if I was being mathematical about it and I said in a 9-minute time frame 3 times, you showing me that means every 3 minutes you made a shift. But what was happening in the other times, right? Where would your knee in those other moments? Right.
See, but that's not how you look at the evidence, Kiki. The evidence, you have to look at
as a juror.
As a juror, right? Okay. As a juror, a juror should be saying, has the prosecution proven to me that Derek Chauvin caused the death of George Floyd? Have they proven it beyond a reasonable doubt? Not just suggested it, not just inflamed my passions, not just, it's probably likely, it's one of the causes. They have to prove it was a substantial factor. So even if they find that his use of force was excessive, you still got to get through causation. Y'all motherfuckers can't even get through force. They can't even get through force.
Get out of my head. That's where I was going with my next question. In terms of the 3 charges that he's facing, which do you think is the highest hill that the prosecution, where it stands right now, would have to climb, and which do you think is the lowest hill they would have to climb at this point?
So in order for them, the highest hill is the 2nd-degree murder, which requires that they prove that Derek Chauvin was engaged in an assault. An assault requires intent to harm someone. That is one of the things that people don't like to assume about police officers, that you intend to hurt somebody. You know what I mean? It's going to be hard for them to translate his actions into intent. And without that assault, you don't get to the murder, right? You got to have the assault as the predicate on the second degree. So
That's the
I
second
don't
degree.
think
Okay. All right.
yeah, second degree murder. I don't think they're going to get that. I think their best shot is third degree murder, right?
That's
Which
the
is
severe one.
right, engaging in conduct that evinces a depraved mind, right? So that's their best shot at arguing that once George Floyd became compliant and or incapacitated, you failed to appreciate the gravity of the situation and or you ignored it, right? And you didn't render aid, or you didn't give him the recovery position, you didn't perform CPR, anything like that. That's depravity. They could find him guilty for that. But even there, it still has to be shown that the depravity that you showed this person is the cause of their death.
The cause of their death. Now, in terms of the causation,
Yes.
okay, let's just say, for example, and I'm just playing devil's advocate here. Let's just say, for example, he took, he did, overdose, as they're going to be able to establish a pattern of him ingesting pills when he gets, into
Right.
the presence of the police. Let's
Right.
just say, for example, that in fact was true.
Right.
Is it fair, or is it proper, or does it make any sense to draw the inference that, okay, you have a man that and that you have already been warned that may be under the influence, right?
Mm-hmm.
That information you have at the
Mm-hmm.
time.
Right.
And if they are under the influence and they're having a crisis of some sort,
Mm-hmm.
even though those two things can't happen concurrently, your knee on their neck and that heart attack or whatever it is can't happen concurrently.
It can, but you have to prove that. You can't just suggest it, right?
Okay.
I mean, well, the defense can suggest it, right? But the prosecution has to prove that it was the knee that was a substantial factor.
So it was the knee that caused the constriction that shut him down, that he ended up dying as the result, because he was already weakened based on his drug use.
Right. So if you remember, so that's precisely it. They have to establish that the knee caused the asphyxiation. And the medical records do not support that claim.
What's up with the medical examiner? Whose team is he playing for? Like when he wrote out that.
Here's the thing: when he wrote it out, medical examiners are on the same team as prosecutors and cops.
That's what I thought. But
so
again,
when he wrote it out, he probably was writing it to help Chauvin.
Not realizing
that they was going to charge his ass, and then he would need to testify and change his story, which he's not.
What is with him? What is with him saying, and this is, or is this completely irrelevant? The fact that he put on a note or made a comment to the fact that if, George Floyd had been found home alone, it would be reasonable to assume that it was an overdose. Well, that's neither here nor there. You're bringing in situations that aren't the case. He wasn't found home alone. It does matter. He was found in the street with a knee on his neck.
No, it does matter because he's looking at it without that information. He doesn't see hemorrhaging on the neck. He doesn't see bruising. So without knowing more, just with what he had, he would have simply concluded that he OD'd.
But he didn't.
Look at DMX. Asphyxiation.
No, I get it. No, I get that. I get that.
Nobody put any knee on his neck. Part of fentanyl overdose is a suppression of the respiratory system.
Yeah.
Right? And so you could have lost your breath because you were overdosing. Right? Same thing, DMX. Overdose, triggered a heart attack, shut off your breathing, asphyxiation, brain dead.
Right, but couple that with somebody sitting on your neck.
No, stop coupling stuff. Ain't nobody sitting on DMX neck.
No couple nothing. Okay.
Ain't nobody on DMX neck, right? So I'm only using that just to parallel it because I've been playing DMX like crazy. Like at the top of the people are like, why is she blasting that? X gonna give it to you. You gotta give it to you.
No, man, it's breaking my
Right. So,
heart.
but I use that because it's right at the forefront, right? And it just happens to be too eerily similar not to draw the comparison.
Akeisha, you have a question. Someone
Okay.
said, what is considered a large crowd?
Whatever a reasonable officer in that situation considers it to be.
But how do we determine a reasonable officer? How do we determine if their officer is reasonable?
That's the standard. It's an objectionably reasonable police officer in this circumstance. That's why they bringing out so many cops to say, yeah, that's not reasonable. That's not reason. That's not what we would have did. Right. Okay. This is also why I said they should have put Lane on, because he's the one who said, let's turn him over. I'm concerned about excited delirium. Right. Because that's at least what one officer is thinking in terms of what's reasonable and what's not. It doesn't matter whether the crowd is large. The key is that the crowd was threatening. Okay.
Well, they felt like it was threatening.
That's threatening. If it's threatening, you're a threat to me. Police, they use that shit all the time, whether they're really threatened or not. It's a cover. It's a cloak for them. They get to use it as a shield and a sword. I was threatened, so I had to shoot him. Right? Well, I was threatened, so I did nothing. Right? Shield, sword.
Right. So, okay. So I guess before I get out of here, because I don't want to monopolize everybody else's time, because I'm sure they got some questions for you. But if I guess for me, my takeaway from watching this clusterfuck is a slow train wreck.
Yeah.
Right. Because if the prosecution's case in chief, he's managed to turn majority of your witnesses into his witnesses, which is brilliant. That's what you should do. Right. When it's time for the defense's case, what do you have to counter? Nothing. Because everything you've already presented has been turned in his favor during your own case. So I guess I would want people to mitigate their expectations on a guilty verdict.
Yes.
It's not surefire. I'm not a legal expert in any way, shape, or form, but from being a critical thinker,
right,
watching what is happening, it's they're being lulled into submission and they don't even realize it.
Yeah. Or they're getting the front row seat of what the criminal justice system looks like when you have a competent.
The prosecution is being lulled into submission.
Oh no, they're doing exactly what they came to do.
Throw the case.
Yep.
You believe that was the intent from the beginning, just to kind of appease everybody, to placate.
Yep, placate feelings. We tried. What y'all want us to do? A jury of 12 people said no. We tried. Why didn't he go bench?
I was wondering that too. Well, during the jury selection, I was like, I wonder why he didn't go bench.
Why would you have a jury with the climate that is around police officers right now? Why not just have the judge, the Republican appointed judge, who is very police friendly?
Who was very friendly to his rulings to the defense.
Yes. Oh yeah. You see, so this is like, for me, this trial is like opposite day, right? Because I don't want Derek Chauvin to be acquitted. I mean, I don't want him to be acquitted. But at the same time, I know the fuck shit that prosecutors do. I can't co-sign that shit, even if they do it with him. Because if they do it with him, they're going to do it with my client. It's a slippery fucking slope. You know what I'm saying? So I find myself, I'm rooting for the defense. I don't want to root for the defense.
I know. It's bad. I don't want Chauvin to get off, but I do have. Okay, I promise. This is my last question.
Okay. This is the last question, y'all.
This is my last question. I promise. Unless you say something.
Question. Go ahead.
In terms of old boy, and the judge supposed to rule tomorrow, possibly, on whether he's going to quash this, the
Maurice Hall. We're talking about
yeah.
Maurice Hall. Yes.
So the prosecution is really kind of like playing cool, like we're not gonna do nothing. We're not gonna do nothing. But I think it's rather coincidental that this dude been in custody since the 22nd. Nobody knew it.
Right.
And then, it's just the optics of it all just seems a little coincidental that you're going to put him over the barrel where it's like, nah, don't say nothing because anything you could say can torpedo our case. You saying that he was falling asleep at the wheel and all that other stuff works for the defense. It doesn't work for us. So we just going to put you on ice here for a moment. And if you say something, we're going to dangle this third-degree murder charge over your head.
Right. That's not going to work. So here's what I think is going to happen with Maurice Hall. Basically, Maurice Hall is the guy who the girlfriend, Courtney Ross, testified is the one who supplied George Floyd with them funny pills back in March when he had an overdose and had to stay in the hospital for 5 days. Don't forget the jury heard about that, right?
Yeah.
Same thing.
That was heroin. That was heroin, though, right? Back in March.
No, it was pills. It was pills. She took the pills too. She said they made her jittery. They made it so they were probably a combination of probably speedball, fentanyl, and methamphetamine. She kept her up all night. But he had been taking those pills, and when she went to pick him up to take him to work, he was foaming at the mouth, and he was having serious stomach pain. She wound up taking him to the hospital. He stayed in the hospital for 5 days. Same guy now.
Did Nelson say that? Did you subsequently find out that was for heroin? And then she said, no, I didn't know. And then he said, but that's when they brought up old girl Shawanda, whatever her name, that was giving it to him.
She said she didn't know. That's what I'm saying. She said she didn't know. Now, the thing with Maurice Hill is the prosecution never was going to call him. But they had to pretend. Because if they didn't pretend that they were going to call him, they would be getting a missing witness charge. Now, a missing witness charge means that you have a witness that has material information, you have custody and control of that witness, and you're not calling that witness because they're going to say some fuck shit that's going to hurt your case. And so what you can do is ask the judge to give the charge to the jury, a missing witness charge, so the jury can infer. You can draw a negative inference from the fact that the prosecution did not call that witness. And you can infer that had he been called, he would have said something that was detrimental to their case. Right? So to avoid a missing witness charge, they subpoena him, knowing he's going to take the fifth. Right? Now, they have the power to give him immunity.
Right.
They could say immunity.
That's why I said the optics of this looks a little off to me. Because if you really thought he had something that could be of value to your case, you know what? Don't worry about nothing. You ain't got to worry about nothing. Just here, say whatever I want. Say that, and you do it.
But the judge knows that the defense does not have that same power, right? I can't call you as a defense attorney and offer you immunity. You could get up there and just fifth me all damn day.
Right.
If I don't advice counsel, I'm going to answer that and right? So I don't have the power. What the judge is going to do, the judge is going to say, you can testify, but you can't ask him any questions that would cause him to inculpate himself. Right, or to expose him to criminal liability. So things like you cannot ask him, did you sell drugs or did you give drugs to George Floyd?
Right.
But you can ask him whether he was sleeping, whether he was nodding off. That you can ask him. There is no danger that you might be charged just because you watch someone nodding off.
So what was the argument that the assistant public defender was making in terms of his very admission that he was there puts him in a trick bag, basically? What lawyers sometimes have to do is make it seem like it's so much bigger than it really is. You know what I mean? They're not coming after him for third-degree murder. You know that. I know that. They know that. That's just a ploy. That's just something to say to sound like, this is serious. And his exposure, he doesn't have any, but they're not going to fucking charge him with anything. And they know it. But they're going to let the lawyer come in here and make that argument and, and sit coy like, yeah, we could charge him.
You know, when
Okay.
they know they have no intentions of doing that.
So
So
let
why
me
can't
ask.
go to Maurice Hill just for that purpose?
So for Maurice Hill, the judge says since he had Nelson submit his questions that he wanted to ask, and he's gonna parse through it and say, yeah, you can ask him this, you can't ask him that, you can ask him this, you can't ask him that. But on some level, does that cause an undue or advantage to the defense in that case? Or are they calling him as a defense witness? Or are they calling him as a prosecution witness? Because he was both their list.
I don't know. I think they both, the prosecution and the defense, subpoenaed him. I'm not exactly sure. The problem with that is if the judge does allow him to testify, they're going to make the defense call him, right? Because if the prosecution calls him, they can't ask him, did you give him pills? And that is going to make it look like they're trying to hide something from the jury.
Right.
Why wouldn't you ask him that? That's been a central issue in this case, whether or not he had those pills, the fentanyl pills. How many did he have? How many did you see him take? Da 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 da.
But if he can't ask them that, and the jury can't consider that because it hasn't been brought, because the judge would have to give them an instruction.
It causes speculation, and that's what you don't.
And you can't unring that bell.
Exactly. That's exactly right. You don't want jurors just in their own mind, in their own world, speculating about things because they come up with the craziest shit. You don't want that.
Yeah.
You don't want that. All right. I see some questions in the chat. Let me see. Why didn't the prosecutor save the eyewitnesses for last to leave a lasting thought on the jury? Yeah, I said that from the beginning, but you know, the truth is the law of primacy and recency is what we work off, right? So we tend to believe that people remember what they hear first and what they hear last. So whether you put them on last or first, it's supposed to have the same effect. But I don't think in this particular trial that truth will bear out. I just don't. Hasn't it been mentioned by the DA that Chauvin knew George Floyd? It was personal. I did not hear the DA say that at all. Did not hear that. I haven't
seen that answered. I've heard it in the streets, but I haven't seen it.
I haven't seen it in the court. Anything about them working together, knowing each other, anything like that.
Was that something that was possibly that they ruled on when we couldn't hear it?
It could have been pre-trial or when we weren't watching, right? Could have been a pre-trial thing, or maybe it was a no thing. I don't know.
Yeah, because it just I always thought that was a little interesting too. But again, I would say this. You can bring that up and you can say it was personal, but how can you prove that?
That's probably why, if it was brought up, the judge would not allow it because it's too prejudicial. First of all, I already said that if they do get a conviction, that shit is going to get kicked. It's going to be overturned on appeal. Why? Because this judge, and I think he's frustrated with himself for allowing the prosecution to bring so many cumulative witnesses that said the same shit over and over and over again. And at some point, it becomes prejudicial. And so I really think that having so many witnesses come in and say, not the right use of force. No, that's not what we do. I think it was overly prejudicial, and it very well may have denied this man a fair trial.
I think all of it is a fair trial issue, you know, in terms of how much exposure has been and being able to find, you know, a jury basically that has not seen or heard what it is. Okay, I promise I'm getting ready to hang up because I got to go, but I got one question because this was the last thing that happened today in court. And it's going to be my last question. What was the point of bringing up that chemist today so that she could testify that the pills that they found were normal levels of fentanyl, but higher levels of, and you know what I mean? But lower levels of the amphetamine, which bolsters the defense's thing that Fentanyl was the part that depressed his central nervous system that caused him to stop breathing. So if it's like, what the fuck is that?
I don't know. I don't know what they're doing. I don't know if they're not preparing these witnesses properly for their testimony, so they're offering more than they should. You know what I mean?
Specifically, what was the percentage? And right, then she followed up with, in your experience, is that normal? You know, is that within the normal range of what you normally see? And she was like, fentanyl, yeah, it's within, you know, a little less than 1%, or very rarely over 1%, but just over 1%.
So if you remember from the opening, the Blackwell, he said, since George Floyd had been a longtime user of fentanyl, he had a particular tolerance level. So maybe he's just trying to establish that these are just regular pills. These are not, you know, particularly strong in any way. They're not particularly different than your average fentanyl pill. And so it wouldn't be something that he would not have been able to tolerate.
Well, I would like to know what was his blood level.
The problem is they don't know how many he took, right? So when Lane approaches him and that door opens and they got that still of him with his mouth open and you see one pill in there, we don't know if that was the last of 10 pills that he was trying to get rid of, right? You don't know.
Right.
You don't know.
And then they were finding partial pills. They found partial pills in, you know, so I know people who, right, but how was that? How did they miss that?
Yeah.
I mean, I know the prosecution was trying to allude to that today, that somehow the fix was in terms of these pills or whatever. Yeah, I get it. But that's a losing battle. But the thing is that it was your people that was investigating it. How did they miss pills? An envelope with pills in it. I'm not saying I mean, it's just bizarre to me, some of the things that are happening. And it's just like they are still not prepared. There's so many of y'all, and y'all still not prepared.
You know why I think they missed it? Because they really didn't think there was going to be a prosecution. We ain't got to collect this evidence. Let's go through the motions. We went over there. Car's clean. Look, we swept it. I got a phone and one pill off the console or whatever it was. Yeah.
This is just bad to watch. It's hard to watch, to be quite honest with you. It's very difficult to watch.
Yeah, it is. It's tough. It's tough, but you know, I'm watching it from a different lens, obviously. And Ron 2000 said, mistrial, the judges on the take.
It's going to be civil unrest across the globe if Chauvin is acquitted. Watching the trial is like watching a remake of the same movie. Which one? The Rodney King movie?
Right. Didn't y'all see that video?
That they felt like, oh, I was in danger because he wouldn't lay down, because I hit him and he wouldn't lay down, so I had to hit him again. Right. He wouldn't lay down. It's like, okay, he hopped up on something and shock. Your body is like, what the fuck? Oh, let me.
Right. But it doesn't matter what you're thinking. It doesn't matter what you're thinking while you're being
taking baseball swings at this motherfucker.
While I'm hitting you. Huh? What'd you say?
They was teeing off like baseball and golf. They were. They were like, get down.
Remember, Nicole McKenzie today testified a little bit. Now the prosecution did object and get her ass up out of there, and the defense was like, "Oh, bitch, stay close, because we're gonna be calling you next week."
Yeah, that was yesterday.
She started testifying about how when someone has excited delirium, this is the magical Negro part. They have superhuman strength.
Human strength.
They either are sensitive or indifferent to pain. They might have an elevated heart rate. And then it was like, oh, that's out of the scope. We didn't ask about no equally, you know, the excited delirium. And so,
okay, but how you gonna have excited delirium when you don't have no pulse?
She's coming back. She's coming back.
My question is, if you have
so this goes to what you say. If he said he didn't have a pulse, that's not consistent with you being concerned about excited delirium.
Thank you. That was my point. Was that my point is, why are we bringing excited delirium up? Because now that points to you when dude says, hey, should we turn him on his side? Because I'm worried about excited delirium. And you said no.
Right.
So what you bringing that back to talk about excited delirium for?
He said, no, we're holding for EMS. That's what he said. You got to say the whole thing. He didn't just say, no, fuck that. We ain't doing that.
Right.
He said, no, we're holding for EMS. We already called. So in his mind, he's thinking EMS will be here any moment. We just got to hold on. It just, as long as these motherfuckers don't attack us, we going to be all right. It just can't be but a couple minutes. God damn. That's what he's thinking. And you know how fast things happen on the street? That's part of what Nelson was getting out of these expert witnesses. Things happen from moment to moment to moment. You got this critical decision-making analysis, and at each moment, you got to reevaluate what you're doing. You got to reevaluate threats. You got buses and cars.
But you never reevaluated the person you had in your custody?
I'm distracted.
How can you be distracted? The reason why you're looking around, but the reason why you're looking around to see what's going on is because you got somebody under you. At some point, this person has to factor into the equation.
I'm doing my job. It's not the first time that doing my job. During a crowd, I'm a cop. That's what happens when cops do shit. Crowds come.
It's not the first time you got in trouble either, and you've been reprimanded. You can talk about that because that's not going to be allowed because it's too prejudicial.
Well, if he takes the stand, and I don't think
if he does, he don't need to. Nelson is doing a great enough job at this point. He does not need to take the stand. Anything he does on this stand right now will only take his defense.
That's right. I agree.
Here's the thing. I don't agree with him. I don't want him to. I don't want him to win. But here's the thing. If it were me, you got to prove me wrong. I ain't proving shit. You gonna have to work for this.
Right. That's right. And that's what he's doing.
Matter of fact, I'm about to cash you my $1 so I can get you on my. Say you my.
What happened? What'd you say?
I'm gonna cash up you $1 so at least I can say I got an attorney. But wait, you don't have reciprocity in the state of Georgia, do you?
No, but I could get in. I could get admitted because New York has reciprocity with Georgia.
Oh, that's what I was saying. Do y'all have reciprocity with Georgia?
Oh yeah, we got reciprocity. Yep. I got you.
Not that I plan on committing.
Let me talk to some other people. I got Al-Shabazz in here. All right, thank you, Kiki. See you later. Al-Shabazz.
Peace. Can I be heard?
Yes, peace. Let's be heard.
I had a lot of questions, and I gotta give credit to Kiki because she asked pretty much almost all of them.
Nice.
I would say this has been a difficult trial for me to look at for so many different reasons because I'm more of like a philosophical person, and it seems like the way that the justice system is set up is not really about truth, it's about facts. And then the judge can decide what facts that he will let in and he won't let in. And that even becomes kind of a troubling thing for me because just as she mentioned, they won't let in the fact that he had been charged for misconduct before. I feel like that's unfair to the prosecution and unfair to the jury even in trying to make a decision of whether this was intentional. But also the judge is not letting in the full body camera footage as well, from what I heard. He's letting in some of it, but he's not letting in all of it. And it's the defense that's trying to actually get that in. So couldn't he, if he loses, couldn't he appeal and say, this body camera thing could have saved me? This other witness that didn't come in that was there could have made my case. Won't these things eventually make him able to appeal?
Yes, absolutely. And I said that a little bit earlier today. I said he has a great appeal if he should be convicted. And that's one of many. We didn't bring that one up, but denial of a defense is an appealable issue, right? And so oftentimes judges have to be gatekeepers of facts because they have to determine which facts are legally relevant. Not all facts are relevant, right? So they have
But the body camera image, wouldn't that be relevant? An eyewitness that was there?
I agree. And I think that it will come in eventually. I think it'll come in, and they're still arguing about that. I think that they're still having arguments about that. And so I think eventually he'll get it in on his case, right? Once the defense takes their case. But that's what the judge is supposed to do. He's supposed to make sure that not just anything comes in. The other side of that, L, is we don't want to convict people based on their past. Right? You did it before, so you did it now. That sort of proclivity testimony is not.
But if Ron up the street had got caught selling weed last month,
it doesn't work for Juan either. It doesn't. The judge would strike a balance. If Juan was so if, say, for instance, Juan caught a drug case, right, and he was convicted of drugs way back or 2 weeks before this case or whatever the case may be, right? Mm-hmm. The prosecution on their case can't tell a jury he was convicted of drugs before. They can't.
Okay, I didn't know that. So yes. Your prior convictions only come in for sentencing.
Oh no, your prior convictions may only come in if you testify.
Interesting.
Right? So if you testify, then the judge would have to make a decision about which of your prior convictions would come in, and then they do a balancing act to make sure that the prior convictions that they do let in aren't so similar to your instant case that a jury is going to conclude you did it before, you did it this time. That is something that judges are primarily concerned with. And so oftentimes that is a consideration for whether or not a defendant is going to take the stand, right?
I would bet my life that he won't take the stand.
Yeah, I don't think he's going to take the stand. Like Kiki said, I agree. He doesn't need to. He doesn't need to at this point. If he were losing, then he would have nothing to lose by taking the stand.
So but right now, why is it that you think that the defense is winning if the defense is winning if the prosecution has had, like, say, like the chief of police guy that they had? That was a very compelling witness for me.
Well, how is it compelling? That man ain't been on the street Monday morning quarterbacking some shit he ain't been involved in 30 years.
But he said it explicitly that this wasn't a part of their training.
I can tell you I'm a millionaire very explicitly and very convincingly, and that shit would not be true. Right?
Yeah, but I mean, you would think with his experience and his expertise, him saying that this is not a part of our training, it's not a part of our ethics, right? And basically pretty much condemning him on the stand. He was the most overt.
But they all said the same thing. All of those cops. Every cop they brought in from training and the use of force was a press play. It's not reasonable. We don't do that. We don't train that. We don't tell that. And then on cross-examination, well, we do have a neck constraint. We do have an unconscious neck constraint. We have a conscious neck constraint. Shit that wasn't coming out on the direct, coming out on cross. And so whatever strides they made on direct examination, they dissolved on cross. Right. So
some of the redirects were good.
Some of them were okay, but I don't think that they did enough. So let's talk about today. What happened today with the audio?
Today was a losing day. If this was boxing, they lost this round.
Obviously on the same day, right? And you only need one losing day as the prosecution, because if I get one of your jurors, you lost every day.
They did better yesterday. Today, I will admit, it was rough.
And I think progressively the defense will get better, because at first, as a defense attorney, you're not exactly sure how you're defending because you don't know what their case is. You can't defend it until it comes. Like, you'll have, discovery, but you don't know how they're going to lay it out and present it. And so you might have to shift and move a little bit depending on how they are coming at you. And so as he's starting to see and appreciate their case and he can see the holes in it, he gets emboldened. He gets better, right? He gets develops a better line of questioning. So you see, as the days go on,
he was on it today. He was on fire. He was on fire.
So, and I don't listen. Just because he's a defense attorney, right? I got that allegiance. I'm just like, get this motherfucker, right? I'm just like, that's just how, listen. And I don't cops. I don't care if they come to lie for the prosecution. And because the defendant is a cop, I don't care if they come to lie for the defendant. They lied. They all came in and lied. That's my position. They all came in and lied and pretended like when you're on the scene, things happen by the book. They don't. Doesn't happen by the book.
No, that is a valid point. But to me, and I'll just be honest and say, yes, I'm hoping he gets convicted in the whole nine. But
I'm hoping he gets convicted too.
Even without that, to me, it seems unreasonable if doing something, I got my knee on this guy's neck or whatever, I'm training them, and I see people threatening me, calling me out my name, saying that basically you're killing the guy. I'm either going to look down and say, "Are you okay?" and make sure that I'm not killing the guy, or I'm going to get up and I'm going to address the people that's threatening me. Him staying there and continuing to put pressure, to me, makes it seem more like he was assaulting George Floyd.
What about the fact that there was 2 other officers doing the same thing? When we look at whether or not his actions were reasonable, objectively reasonable for a police officer, there were other officers doing the exact same thing. Nobody stopped him, towed him, turned around. None of that happened, right? And so that's
someone made the suggestion of turning him over, though. We're starting to get somebody's consciousness.
Right, but the prosecution is not using him as a witness. See, so what the prosecution should be doing, this is kind of why I'm a little bit frustrated, because I am a former prosecutor too. And this case was a slam dunk. They could have done this better, right? You get the police officer who told you who told Chauvin to put him on his side.
Give him immunity.
Give him immunity. Put him on the stand. You know, he would take that immunity.
So it begs the question why they aren't giving him immunity and they aren't giving this other guy immunity.
They don't want a conviction. But they don't want a conviction because this is all just, something for them to do. Scobay, yes, Sandoval. Don't be telling people you know about Sandoval. Sandoval is the balancing test that we were just talking about here in New York. That's the name of the Sandoval hearing. So you got any more questions?
Well, I mean, I kind of asked it earlier, but is there any reason you can think of that justifies the judge not letting in the full camera footage?
It's prejudicial. It's too prejudicial. If it's more prejudicial than it is probative, then it's not admissible. Meaning that if it's going to be more prejudicial to the jury to see it than it is proving a fact in this case, then it's not relevant. So depending on what it is that is being said, right? It could be either hearsay, it could be an evidence issue, right? Maybe it's hearsay, right? Hearsay is a statement that is made out of court that is now offered for the truth of the matter asserted.
But it's the defense that wants it in. It's the defense.
So what? The rules of evidence apply to the defense too. If it's hearsay, it doesn't come in, right? If it's prejudicial, it doesn't come in. The judge has to protect the facts, whether they come in through the defense or the prosecution.
This is just tough for me to understand. This just doesn't serve the truth, because I feel like as a juror,
a trial has nothing to do with the truth. So,
oh my gosh.
So let's disabuse ourselves of that idea, right? Because that's part of managing your expectation. Trials have nothing to do with the truth. Trials have to do only with what can be proven. That's it. Have nothing to do with
is this another benefit of if this were, because I think the other day I asked you about a bench trial, and you was like, that's kind of how you would have went with this, especially since you know that this judge is really pro-police, pro-cop, or whatever.
Of course.
He's going to look. So if there is a bench trial, the judge can then get all of the facts, and he wouldn't be throwing stuff out like he would in a jury trial. So the judge would be able to essentially do all of the facts and make a decision without stuff being ruled out as
no. The judge still has to comply with the rules of evidence, even in a bench trial. Right? The defendant is still entitled to a fair trial, even if it's a bench trial. So you don't throw the rules of evidence out. So
he's going to deny himself evidence. He would say, "I'm not looking at this body camera footage."
Yes, he has to do that.
This is weird.
You can't consider some evidence that is either prejudicial or irrelevant, or something else is wrong with it. You just can't consider it simply because you're the judge. Remember, if he gets convicted, there's going to be a whole set of other judges looking at what happened at this trial. And so if he considered evidence that should not have come in, it could be thrown out. So the rules of evidence
the same way, if this body cam footage is good and it in some way I guess exonerates Chauvin, couldn't that would be, like you said earlier, that would be something that would be considered for an appeal?
That would be an appellate issue. Absolutely.
Oh goodness.
That would be an appellate issue. But
This
again,
system is
you know,
wild.
yeah. So, but they are going to make a full record and make sure that each side gets to argue whatever it is their position is on why it should or shouldn't come in, and then the judge will make a decision about that. That's right, Kiki. Trial not about the truth. OJ did it. Free Bill Cosby. Belton Nick. China Doll, I appreciate you too, sis. Rico Warren, all about what you can prove and intent. That's all that matters. What do you think about causations, Al?
I think that I think that you said the other day that there was a second autopsy or medical report that leaned more towards the prosecution's point. I think that they need to find that and find it quick. Are they not bringing that guy?
It ain't lost. Ain't no finding.
Are they not going to? Are they not going to bring that into the trial?
From my understanding, Dr. Bodden is not on the witness list, and he's one of the doctors that was participated in the second autopsy. Yeah,
so when they are basically throwing the case because they're leaving causation up to. They just leaving causation in the wind because causation hasn't been proved yet. There's a lot of doubt on pretty much how he died. Then,
no, you coming around now?
They will have that reasonable doubt because the causation is everything in this case.
Everything. It's everything. It's absolutely everything. Yes, and knowing what they know about the report that's in with the doctor they don't want to use anymore. They absolutely should have called Dr. Bodden for the second autopsy, but they're not doing that. So
that's almost unexplainable in terms of why they wouldn't. It's almost unexplainable.
They must have something, right? Well, maybe they got a different. I don't know. I'm really. This is the part of the trial.
He would be way more valuable to them than the guy that they paid $10,000 to.
Well, yeah.
He would actually be the first. The causation would be the first. He should be like the first witness in the lineup, right? Or the last, depending on how.
Yes, causation witnesses are coming up. They might be Thursday, Friday. The prosecution might be done by Friday, Monday.
What do you think that the defense is going to do when they actually come up to the plate?
Defense is going to call all expert witnesses. Going to call expert witness on the use of force. Going to call the expert witness is going to talk about that maximum restraint technique. Going to show training videos like they have that show officers placing their knee in and about and around that upper back neck area. He's bringing back this Nicole McKenzie to talk about.
They wanted her back yesterday. Yeah.
Right? So he's got a game plan. He's got a game plan, and he knows
and it's going to be hard to. It took. The defense attorney a little while to warm up and get his cross going because I felt like he kind of lost yesterday. But today he was really hot. He was on fire.
Right.
I don't really see, based on the demeanor of the prosecutor, I don't really see him doing a good job in cross. I mean, he did a good job in redirect.
Let me just tell you, so you'll know, right? Prosecutors are notoriously bad at cross-examination. You know why? Because they never fucking get to do it. Who they gonna cross-examine? Defendants don't take stands, and hardly does defendants put cases on.
And how come they aren't like objecting to anything? Like, maybe I watch too much TV. I do like lawyer shows like All Rise and all those kind of shows, but I don't see a lot of objections. Like, nothing is argumentative. Nobody's leading a witness. Like, I don't see any objections pretty much either way. But
no, they're there. They're just not probably as audible because of the manner in which they're being dealt with. Objections and sidebars. So the objections
I see a lot of sidebars. I do see the sidebars.
And overruling and all of that. I'm hearing them. I hear them. Now, they may not object to certain things because, one, they don't want to alienate the jury. Objecting is very strategic, right? It's very strategic. You either are objecting because something is very objectionable, or you're objecting because somebody's making a really good point, and you got to interrupt that shit.
That's very strategic. But there's been times. That was yesterday. I seen prosecutor, he was all the way leading. He was like all the way leading. And even though I wanted him to do his job, but even I said objection. I mean, I was like, goodness gracious.
You're like me. I'm screaming at the TV all day. Like Nelson, object. They are leading. I mean, they really literally just hook up a rope and just lead their witnesses wherever they want to go. And I'm just like, this is crazy. Why is Nelson not objecting? But again, he doesn't want to alienate the jury either. He doesn't want him to make it seem like, he's the bad guy, or he's trying to get information from them. Right. So it's strategic.
I have seen them rephrase themselves once or twice.
Yeah, right. Right. Sometimes the question is so objectionable that nobody has to object. The witness does. The witness, like, can you rephrase that? If the witness got to ask you to rephrase your damn question, you need to
I've seen the witness ask them to rephrase the question. Yes. I think yesterday. I've seen that.
Couple times. And that's to tell you right there, Nelson should have objected, because clearly the question is confusing or it's not properly formulated. Right. So that's a basis for an objection. Objection form. A lot of times they were asking compound questions, which I call the multiple choice questioning style, which is highly objectionable. Like, so when you got there, did you get in the car? Did you go in the store? Did you, motherfucker? That's not. I'm sorry. I'm gonna need you to not give somebody suggested answers to your goddamn question.
The prosecutor probably could have also done a better job when he was asking him about the audio. That was kind of a weird thing, because he basically got him to agree to something that he didn't really hear, and then he got it back on redirect, but he could have addressed it.
So let's just talk about that real quick, right? So on cross-examination, Nelson played a portion of the audio where he says to the witness, and I think this is Ryderson, this is James Ryderson, who's former NYPD officer, was back in narcotics in New York. He's with the Criminal Apprehension Investigation. He asked him, you listened to all this footage, you looked at all of these videos, did you see this part? And he played the part where you hear George Floyd say something, and he's like, did you hear what he said? And he says, no. Then he goes, listen to it again. He plays it again. Did you hear him say, I ate too many drugs? He goes, oh, yes. Now, he's excused as a witness. When he is recalled, the prosecution plays an extended part of that exchange where you hear a little bit more of what George Floyd is saying, and then the prosecutor re-asked the question. Now that you've heard the whole context of the recording, what do you think you heard? And he's like, oh, he didn't say I ate too many drugs. I think I hear him saying, I didn't take no drugs. I didn't take no drugs. The problem with that is that
I looked at that as a win for the prosecution.
That's not a win. You know why that's not a win? You know why that's not a win? Because he already allowed himself to be manipulated one time. The first time.
That's true. Yeah.
So the second time, you think as a jury, don't think that the prosecution took his ass in the hallway and was like, yo, son, you can't say that he said that. I'm gonna play this shit again. We're gonna do this over. And he came back and he changed his testimony. How much credibility is anyone going to give this guy? I'm not giving him any credibility, because it seems to me that whoever's asking the question, you're just going to acquiesce.
Yeah, they were just saying yes a lot of times, or I agree. And
you would agree, right? You would agree, and you would agree, and you would agree with me, right? And you would agree, and you would agree. And at some point, I'm just like, these some agreeable ass. What you didn't do this time, right, with this section of the witnesses, you didn't see any emotion. There's no crying, no emotion. You didn't see any hostility from the witnesses either, right? Remember Donald Williams? Did you call him a pussy? If that's what you heard me say, if that's what I said on it, like, we didn't see any of that. You don't see any of the police officers responding that way, which is why I said that is going to stand out for jurors. There's no need for you to be hostile. Same thing with the firefighter. There's no need for you to be hostile to the defense attorney. That man is doing his job. So, all right. Any more questions, Summers?
No, I don't have any right now. My battery's about to die, but I thank you so much for answering all my questions. When you come back on here again, I'm going to be back on here again. Y'all make sure y'all like this channel and subscribe. Hit the notification button and all that good stuff. Thank you so much, sister. It's always a pleasure watching and talking to you.
Likewise. Thank you for joining me, brother. Take care. Be well. All right. All right. Okay, so I've been kind of ignoring the chat just a little bit. Right, China Doll, the jury already heard the first statement. Yeah, they heard them. So the possibility that that's what George Floyd did say is going to be embedded in their minds, right? And that whole Jedi mind trick shit, that is important because what's going to happen is the jurors, they're going to go in the back and they're going to argue. They're going to argue about whether or not he said he ate drugs or he didn't eat drugs. They're going to argue about whether or not the knee is on the neck or the knee is on the back, right? And we don't even know what they're going to argue about causation for. They might argue about whether or not the drug overdose caused him to stop breathing as opposed to the knee. You know what all that is? That's confusion. You know what happens when you're confused? When you are confused, that means you are not convinced. When you are confused, you are not convinced. The prosecution, in order to get you to guilty, must convince you beyond a reasonable doubt of this man's guilt. They ain't doing it. They ain't doing it. It's a very, very high standard, and it's even higher because he's a cop. It's even higher because he's a cop who was engaged in his job. It's not like he was off duty and he shot somebody, right? That might even be different. But he was a cop at that time, acting under the color of authority. It's not easy. It's not an easy thing. I think Nelson is letting them hang themselves. They're leading their witnesses and he's still flipping them on cross. Absolutely. Absolutely. Because you know why they're leading them? Because they're not prepared. Because these witnesses are not prepared, and it might not be as evident with them because they are professional witnesses. Right? Because that's all they do is they come and they testify. They know that when they're talking, look to the jury and look back to the questioner and explain your answer to the jury and then turn back to they're professional witnesses. You didn't see that happening with the civilian witnesses. It was more readily apparent how unprepared they were. Right? So Nelson sees their game. Y'all not preparing these witnesses. I'm going to let them get up there and say all manner of bullshit. And then I'm going to turn it around on them. And that's what's happening. Even the officer, the first officer, the second officer, Ryderson, the one who did the flip-flop with I heard him say it. No, I didn't hear him say it. That guy, what do I have on him? He investigates use of force. He said that the gear on him, on Chauvin, was 40 pounds heavier. I mean, it was 40 pounds, which would increase his body weight from just the 140 that he weighed to 180. But he wasn't convincing. Let me see who else was on there. There was Sergeant Kerr Yang. He talked about the critical decision-making model. They talked about Graham-Connor factors. I don't know if you guys know what those are, but those are the things that you consider when you are responding to a crime scene. The severity of the crime at issue, whether or not the suspect poses an immediate threat, and whether or not the suspect is actively resisting or attempting to evade arrest by flight. You know, they're going to argue that George Floyd was saying he can't breathe as a ploy to keep from being arrested, along with the claustrophobia, along with the coronavirus, along with, I'm a good guy. All of that, right? All right. This is worse than watching Colin Ferguson defend himself. Oh, Belton, you remember that? Listen, I'm from Long Island, so I remember that. That was crazy. Mona, enjoying the commentary. Thank you. You making me nervous. I'm sorry, Mona. No, it hasn't been a win. I don't see a win. I don't see a win. It's a setup. Ryan said it's a setup. 30 to 40 pounds seemed not convincing. Yeah, it seems like it was a setup to be this way. I think, listen, they have to put it on like Oh, I see you in the private chat now, Kiki. I know where it's at next time. They have to put it on. They have to make people think that they are in the pursuit of justice. They have to make you feel good. They have to placate and pacify you by putting on this shit show, pony show of a prosecution. Y'all not fooling me. Y'all not fooling me, because I know if I was the prosecutor, this trial would have went a whole different way. Whole different way. Those bystanders wouldn't have came on until the end. We would have started with causation. Let's start. You caused his death. Now, this is how you caused his death. You put your knee on his goddamn neck when you shouldn't have did that. And you know what? You traumatized a whole lot of motherfuckers. Let's hear from them. That's how this trial should have went. They make me sick. They make me sick. All right, let me just look through my notes and see if there's anything else. Oh, we passed the hour, y'all know. Oh man. All right. Let me see. Yeah, how y'all miss pills in the car? Right, Kiki? How y'all miss that's and I've had that happen in cases where you make a request to go and inspect the evidence, where you can't touch it, you just looking at it, right? I've done that, and I'm like, well, where's this? And they've had to go out and recanvass or research either a house or the crime scene or a car, and then they find additional evidence a year later. You know what that speaks to? Incompetence. That's what that speaks to. And if you think Nelson is not going to make a big deal about that on summation, watch. You watch. Watch. All right, so we talked about Maurice Hall. We talked about the magical Negro and the superhuman strength. Oh, we didn't talk about this. There was testimony from, don't remember her name. Basically, they were asking about whether or not, if someone says that they can't breathe, is it true that if they can talk, then they can breathe? Y'all remember that testimony? And she basically said, well, it's sort of she didn't say, I'm paraphrasing, but it's sort of a misnomer or a misunderstanding that people think that you can breathe because you can talk. It doesn't mean that you can breathe adequately. Okay? Doesn't mean you can breathe adequately. That was the caveat that she said. She didn't say it doesn't mean that you can breathe, period. She didn't say that. Right? So what does that go to? Right? Because everything has to go to something. That goes to the mind of the officers. If they think that if you can talk, you can breathe, then they're not giving credence to him saying he can't breathe. Because they're like, if you can talk, you can breathe. And in fact, the response was, you're fine. You're fine. You can breathe. You're talking. They even said that to him. And then they said, just calm down. Take a couple of deep breaths, like relax. Right? Listen, I want him to go down like everybody else, but I'm going to manage my expectations, and I know what I see. Knee on the neck of an apprehended suspect already under control. Cop goes straight to jail. Yeah, no, that's not going to have it. Love like the sun. I'm sorry. No, I wish that was the case, but that's not going to happen, because guess what? If I put my knee on your neck and I don't apply a lot of pressure, or if I put my knee on your neck and you got super thick neck, right? Like my personal trainer, I put my knee on the neck, he ain't even going to know I'm there. He like 300 pounds. I put my knee on his neck, he ain't going to see it. He ain't going to know, right? So it's more than that. You're stopping. Your analysis is stopping when it should continue. So the next step for that is the knee on the neck, and the knee on the neck caused his death. You can't leave out causation. You can't leave out causation, and causation has to be proven. Has to be proven. So let's see if they prove it, because that's what's coming up next, right? We should be done with the use of force experts and the training experts and all of that nonsense. And we should be on to medical experts and causation and whatnot. That should be what we hear in the next coming days. And when we hear that, I'll be back, so we can talk about that and, find out what's going to happen and when the defense is coming on. All right, so I'm going to go through the chat one more time just to see if I missed anything or anyone. because you can talk underwater, say a few words without taking a breath. I can have asthma attack and still talk, but just can't breathe adequately. Right, adequately. But I might not respond to you because in my mind, I think that you can breathe fine. You can breathe fine. And remember, it's what's in the mind of the officers at the time. And all of what he said, he's verbalizing what is in his mind. You can breathe. That's what he believed. It wasn't Chauvin, but it was his fellow officer. So if they all are thinking the same way, right? I'm going to impute your thoughts to the other thoughts because all of y'all are in the same situation and all of y'all are experiencing the same thing. So y'all should be thinking the same shit, right? That's why I think they should have put that other cop on. Did the defense text guy say that if you can talk, you can breathe, and he was training recruits, so this was some police officers adopt? I don't remember, Tom. Oh, no, the defense text, did he say that? I don't remember because I couldn't watch every second of the trial today. But if he may have said that on cross, and which is why if he said it on cross, I can imagine why the prosecution would have brought that up with what's her name? I believe that was Nicole McKenzie, if I'm not mistaken. Yeah, I think that might have been why they brought that up to sort of tamper. See that, and that's the thing. They have their own witnesses contradicting each other. That's problematic. The defense hasn't put on any witnesses. He's just turning their witnesses into his own. And he has them saying things in opposite of each other. And that looks crazy. That looks crazy. Right. They contradicted each other. And yeah, on more than one occasion, that has been happening. Yarmis Potter, right now, if I had to vote based on what I see on the evidence that has been presented, I would have to vote not guilty. Now, I would have to vote not guilty because your vote must be contingent on only the evidence that has been presented at the trial. And you must be convinced beyond a reasonable doubt. And you haven't even heard evidence of causation, so you can't. I certainly haven't been convinced that it was the knee on the neck that caused his death, not with all these other factors, right? And so I would be bound by law to vote not guilty, right? So we'll see if that changes. Remember, he has the presumption of innocence. He is cloaked in innocence. He remains innocent until the defense proves him guilty beyond a reasonable doubt. And if they can't do that, then he walks out. Yeah, Lady T, I'm sorry. I don't like it either, but you know me. I got to give it to you. I got to give it to you straight. If you were forced to bet at this point, what would you put money on for the manslaughter charge? No, I would put my money on murder 3. You know what I miss? Murder 3, because murder 3 is the depraved mind, meaning that you were engaged in some dangerous behavior and you failed to appreciate how dangerous it was to someone, right? But even that, you still have to prove that depraved mind and the acts that came from it caused the death. You don't get around causation. And you shouldn't want, think about it. Think if it wasn't Chauvin. Think if it was your brother. Right? I know that, and this is why I'm this way, because when I'm in court, the defendants don't look like Derek Chauvin. I want them to get a fair trial too, right? I want them to get a fair trial too. I don't ever want anyone to be railroaded. I just don't. Because if they railroad that motherfucker, they're going to railroad your brother, your father, my clients. I don't want that. I don't want that. I'm not for the slippery slope. I don't want that, right? And so you have to think, if that was someone who wasn't so despicable, right? So despicable, because the jurors don't see him that way. Some of them jurors haven't even seen the video. Would you be convinced on the evidence that you have seen up until this point to find him guilty? You have to say no, because you haven't seen any evidence of causation. And I'm not convinced that he didn't die of a drug overdose. I'm not. Because they had witnesses who came in and said fentanyl suppresses your respiratory system. So we'll see. There should always be a pathologist hired in the victim family. That we talked about that T-Smooth. There is a second autopsy. The prosecution is not calling the doctor who did the second autopsy, right? So I don't know if it's 2 toxicology reports, but definitely, there definitely is. And the importance of this other report that Dr. Bodden did is my understanding from I actually went back and watched the press conference. They did find evidence of hemorrhaging in the neck that would lend itself to the knee actually causing some sort of constriction and contributing or causing the asphyxiation. There you go. Why wouldn't you put that in? I don't, it's mind-boggling. All right, couple more. Oh, it's 10 o'clock. We gotta get up out of here. Cops were at least extremely legally negligent. Negligent is a civil concept. Well, there's some negligent. They're not charged with negligent homicide. I don't even know if they have that here. I mean, have that in Minnesota. They have it here. You can get probation that's manslaughter. If the jury have not seen the video, they must be immigrants. Some of them are. Some of them are. Some of them are. And I don't know what that means in terms of their understanding of the justice system and all of that. So I don't know. Y'all, Miss Potter, I love you too, sis. Thank you. All right, I'm gonna get up out of here, family. So if you guys are on the YouTube channel, please like. What do you gotta do? You gotta subscribe. Subscribe. Hold on, I got some stuff I'm supposed to put on here, like my banners and my email and my Cash App. So my email is ikespeaks@gmail.com, and my Cash App is ikespeaks. It's $Ikespeaks. Feel free to support the platform because, as you can see, I still need a big green screen. So thank you to those of you who did Cash App me. I appreciate you. And I'm putting that in the green screen fund. And then I'm gonna have a building fund. And I'm stop playing. I'm just messing with you. But every little bit helps. Appreciate you for joining me tonight. I'll probably be back maybe Friday night. We'll see how it goes. We'll see how much testimony. If it gets crazy tomorrow, I'll be back here tomorrow night. We're going to see how it goes. So y'all keep watching. It's your girl Ike here. I love you. I really do. I just would not do this. I love you. All right, y'all have a good night. Stay safe and mask up. Peace.